Good evening to everyone who's joined, and thanks so much for joining. This is the first part in a two-part series that Coram Chambers is putting on for everybody who is aiming to be a pupil barrister. And the reason we're doing this is because we want to help everybody who wants to be a pupil barrister, particularly in family law, anybody who wants to join Coram Chambers in particular. But actually there's more than that to it. First of all, this is our attempt to be transparent about what it is we're looking for in our potential future pupils. And secondly, it's our attempt to do what we can to address the issues of diversity at the bar. I think we would all acknowledge that the bar is not nearly diverse enough to reflect the population it purports to represent. And we hope that if we are transparent about what it is that we're looking for in our pupils, more people, and particularly people from non-traditional backgrounds, will have a sense of what it is they need to do to make their applications stand out and consequently become pupil barristers and enter the profession that way. So this is our attempt to slightly level the playing field, as well as to just make sure that everybody comes at this and their applications from a level playing field. So I'm going to start by introducing the panel this evening. Alex Lang and I, we're both members of Coram Chambers, and together we run pupillage, and that involves the pupils as they complete their year, but also actually the application process itself. So we're both quite heavily involved in that. But joining us, very kindly volunteering, is Srishti Suresh, who was called in 2018. There she is waving in a jolly way. Now, Srishti is, she's just, you may be aware, she's just won our this year's Young Barrister of the Year, which we're also thrilled about. And one of the reasons that she's going to be so useful in this webinar is because not only has she recently been through the application process that you're all going through, but also she's actually been quite heavily involved in the marking process as well. So she's kind of gamekeeper and poacher at the moment. So she has a high level of value in this webinar. And she's also joined by Olivia Kirkbride, who's our most recent tenant. We are all very thrilled to have taken on Olivia. She, again, has volunteered her time to give you some tips about how to navigate your way through the pupillage ordeal, the pupillage application process ordeal. And most thrillingly, we're joined by Alice, who's our current pupil, and we are so delighted to have Alice. She's one of two pupils we have at Coram. We have Daniel Taylor and Alice Thornton, and Daniel will be joining us on the second of the webinars that we hope to do, and that's on the interview process. So just to recap, what we want to do in this session is talk to you about written applications, how to maximize your marks in those written applications and get you into an interview, because of course that's the whole point of a written application. It's there really to maximize your potential of getting a first or second round interview. So having before I hand over, the session that we aim to do on interviews, which will go into the in-depth analysis of what makes an interview candidate stand out, we hope will take place on the 17th of February at around the same time, and we'll be emailing you about that. So I'm going to hand over to Alex, and he is going to explain to you a little bit more about how we mark the forms that we have. Thanks, Alex.
Thanks, Anarkali, for that really helpful introduction. Really, what I'm going to do is spend 10 minutes or so talking about four things. The first is what happens to your application form once it hits our desks at Coram Chambers, so how we deal with it. And in many ways will be similar to other sets, so hopefully it gives you some insight into that also. The second thing is just to talk through the criteria that we apply to application forms. And in particular, just spend a bit of time going through the allocation and distribution of marks to the various questions within the application form. Thirdly, I want to give some general tips on to use an Arkley's word, maximizing your application. So how you set it out, what you need to focus on, etc. And fourthly, I'm going to give a few bits of, I hope, helpful miscellaneous information, which should equip you with a slightly fuller knowledge of how it all works and what you need to be thinking about when you're sitting writing these forms. So let me start then with the first of those things. Your application form comes in to us. And the focus from our perspective is to remove identifying information and then to ensure that your application form is given the best possible chance of being treated equally to the application forms for all of the other people who are applying. So the way we endeavour to achieve that is that at the start of your application form, you may have seen if you looked at the Coram one already, if not, you'll see in due course, there are sections on personal details, in and call information, and special requirements. Before that goes to anybody marking the form, all of that information is stripped away. Rather than your name, you're given, perhaps slightly bleakly, a number, and your form is then double blind marked. So what that means is that two members of Chambers from different backgrounds and of different seniority will each independently mark your application form according to a list of objective criteria, which I'll come on to. And what we then do is that if there's a significant and meaningful disparity, meaningful in the sense that it may affect whether or not you're going to be invited to interview, between blind markers 1 and 2, your form will be blind marked for a third time, and then the average is taken. So that's how we deal with the forms. And as I say, hopefully we do so in as fair a way as possible. Perhaps more interestingly then, what are you guys meant to be thinking about? What criteria are you aiming to hit when you're completing your application forms? Well, we have 7 criteria that we apply, and it may just be worth taking a note of these. They are academic achievement, intellectual aptitude, work experience, mini pupillages, the reasons you give for applying to us at Coram, your essay question, and overall presentation. I'm going to come on to how those marks are allocated within the form and the weight that we give to each criterion. But let me just add that the application form is marked out of a total of 35. Irrespective of those criteria that I've set out, there are an additional 2 marks that are available for extenuating or exceptional circumstances. But going beyond that, we recognise that for a number of applicants, it may be the case that those 2 additional marks don't do justice to the exceptional circumstances that they have faced. And so the blind markers have the ability to flag up that despite the applicant not receiving a sufficient number of marks otherwise to pass to interview, that the extenuating circumstances are such that they should automatically be given an interview. Additionally, and finally, up to 2 marks can be deducted for poor spelling, grammar, and other errors such as typographical errors. And that's separate to the score that I mentioned for overall presentation. And just pausing there for a second, let me say that really that's a waste of marks. So if you're sending in an application form that has typographical errors because you haven't taken the time to go through it, or has grammatical mistakes or spelling mistakes, you are throwing away marks, and that may well cost you an interview. So please, everyone, focus on that and don't lose marks on those points. So let me just spend a couple of minutes then drilling down into each of those criteria. And again, this may be very helpful to take a note of. So number 1 was academic achievement. And the way we do it is if you got a first in your undergraduate degree, you automatically get 4 points. If you got a 2-1, you get 3 marks. You then get 1 additional mark for any postgraduate degree that's not your law conversion course or BPTC. And up to 2 marks are available for excellent pre-degree grades. So that would predominantly mean A stars at GCSE and top marks at A level or equivalent. And it doesn't matter, of course, whether you've done baccalaureate or traditional English exams. We're perfectly content with each. So there's up to 7 total marks there for academic achievement. Moving on to intellectual aptitude, that's the second criterion, and there's 5 marks available there for you. And really what we're looking for is a breadth of intellect and the demonstration of academic achievement beyond the confines of degrees. So that could be, for example, languages spoken, prizes, scholarships, awards, writing, so publications of books or articles, doing really well in a moot or debating or other forms of public speaking, positions of responsibility that may demonstrate intellectual aptitude, and any other relevant extracurricular activity that demonstrates that same point. So we're open really to whatever you've done, as long as it demonstrates intellectual aptitude in some sense, and would expect you on the form to explain why it is, if it's not obvious, that that particular activity demonstrates that intelligence. The third criterion then, work experience and employment, up to 10 marks for this. And let me say at the outset that lots of people worry that for whatever reason, they may not have had the same opportunities to undertake heaps and heaps of what may seem to them to be relevant work experience. So just 2 points, I hope, by way of reassurance in respect of that. The first is that the way we distribute marks for work experience and employment is that the large part of the marks, is 7 out of 10, are for the explanation as to why what you've done is relevant to a career at the bar, and only a significantly smaller number of marks, 3, for the experience itself. So that's the first point. And the second is this: when we're talking about work experience and employment, that doesn't mean, although some people have done it and it's brilliant, it doesn't mean that you need to have been judicial assistant to a judge in the Court of Appeal. We're equally content if you spend 2 years working in your local Tesco, as long as you can explain why it is that that experience has equipped you well for life at the bar. Okay, so it's a real focus not on amount, but on the quality of what you've done and the explanation of the application of that. Criterion number 4, mini pupillages. So this is relatively modest in terms of the marks that we give to this, up to 2 marks. And again, so similar to with the position in respect of work, here we don't give any marks for the mini pupillages themselves. So just saying I've done 5 mini pupillages gets you 0. What we want to see is how you relate your experiences during that work experience, during that mini pupillages, to the present application. So can you show to some degree an understanding of how chambers work, an understanding of life as a barrister, the identification of how that has helped you reach a decision that you'd like to be a barrister, the different demands on us, why it is that you like family law, and why it is perhaps that you want to work at Coram in particular if you've done a mini pupillage here. But if you haven't done a mini pupillage here, that's absolutely fine. You're at no disadvantage at all. Criterion number 5, reasons for the application. So 3 marks for this, and there's a 151 word limit on our application form. And the question is very simple: why are you applying for pupillage at Coram? And what we want is, we want to see someone who cares. We want to see an applicant who's taken the time to learn about us, to read about what we do, what our members of chambers do, and just to explain why it is that you're interested in working at Coram as opposed to any other family law set. And we don't for a moment expect you to have a really detailed knowledge of working life here. But what we absolutely do expect of you is that as a start, you've gone onto our website, you've read about our interests, about our work, about our cases, and perhaps you've gone on from there to read a few links, to read some cases, and actually to show that you've devoted sufficient time to us and to the application form to make us want to in turn devote time to you and to inviting you to interview. Number 6 is the essay question. So quite a lot of marks for this, up to 7 marks. Again, let me make something clear at the outset. There is no wrong answer to any essay question in any year. What we want is someone who has thought about the issue, and it's normally a fairly difficult proposition that you're asked to think about, but who's thought about the issue, who has done some research into what it is that's being said, and is then able to set out in a clear, precise, and concise fashion the argument that they wish to make, either for or against the proposition. And it's important that you recognise whatever tension it is that the proposition is flagging up, but you then go on to make an argument in respect of that. And then the 7th core criterion is overall presentation. 1 mark for that. I've said that separately you can lose 2 marks for sloppiness, but that's about presenting a neat form that's crisp and easy to read. And of course, that's actually very important in real life as a barrister, because your client or the state will be paying you, including for your written advocacy, and that's a minimum expectation. The third thing that I want to touch on is about the presentation generally of your answers. Now, one of these things I said already, be concise. The truth is that your application form will be sitting in a pile of other application forms. If you write dense paragraph after dense paragraph, you are running the risk that the marker whose job it is to give individual marks for each answer may not fully appreciate the points that you wish to make, however carefully and closely we endeavour to mark it. So try to set out clearly, precisely, succinctly what it is that you want to say. Subheadings, bullet points, all of those are, in my view, great things. Focus on answering the question. And please, forgive me, this sounds obvious, but please don't copy and paste answers from other forms. It may seem hard to believe, but every single year we read application forms where people have clearly copied and pasted it from something else, and that's never going to leave a good impression on your marker. Final thing then, the 4th point was just a few miscellaneous bits of information that may be helpful. So as I say, the form is marked out of 35. Normally you need about 30 marks to get through to the first round interview. And as I say, there are exceptions, for example, for extenuating circumstances. If something changes between the point at which you submit your application form and the point at which it falls to be considered, we are content for you to send an email to Ginny, who kindly administers this at the pupillage address, to let us know about any changes. And note also, and this is I think a really important point, that it's very common not to get pupillage the first year. It's very common to apply to Coram and be unsuccessful the first year, but to be successful in future years. So don't be put off for a moment. If you've applied once and it hasn't quite worked out, refine your form, think about what I've said and what my colleagues are going to say, and have another go. We'll be delighted to read the application again. We'll read it with fresh eyes, and we'll be very pleased, as I say, to consider it. So those are the points for me that I wanted to cover, and I think it's now over to Srishti to go on with the next part of the talk.
Thank you very much. I wonder if we wanted to hear from Anarkali first, or if I should go ahead, because I have very sneakily asked Rakaya to share her screen for me in order to show the questions, because I'm worried I'm going to break Zoom if I do it myself.
Okay, fine. So perhaps what I'll do is thank you, Alex, by the way. That was really nicely done. What I'll try and do is explain what we're going to do in the next part of this webinar, which is that we're going to compare good answers with answers that got pupillage interviews, so that you can see how we analyse those 2 answers, and you can now, hopefully, using this information, elevate your good answers into excellent answers. So that is what we hope, you know, one of the benefits you're going to get from this session. That's one of the concrete things we aspire for you to take away from this. And while we're focusing on the essay part of the question, which, as Alex has explained, attracts a lot of marks, I do want to make it very clear, we've done some analysis on where people do lose their marks most frequently in the application process. And the things that they lose their marks on are academic achievement, intellectual aptitude, the reasons for the application, and the essay question. Now, I just want to say this before we move to Srishti, Olivia, and myself when we do this analysis of questions. But, you know, when you're writing a form, what you will identify is that there is, a form of this nature has obviously got a combination of static information and non-static information. The static information is obviously your GCSEs and A-levels and your degree result, which you can't really change. And so if you're not going to be massively strong on your academic achievement, that's, you know, there's not loads you can do about that apart from reset stuff, which is going to be quite messy and time consuming. But I really want to encourage those of you who don't necessarily feel that they've excelled or shown really a true reflection of their intellectual abilities throughout their studies, because what you can do, as Alex, I hope has set out, is you can make those marks up in the intellectual aptitude, showing what other activities you've done, which go to show that actually you're somebody that has got all the qualities that we're seeking. And also the reasons for applications, people drop those marks all the time, and they're really easy marks actually to make up. So it's just carelessness. And the essay questions, and this is really what we're going to help you with the essay questions. So what Srishti, Olivia, and I have done, as I said, we've gone through, we went through 2019, 2020, and 2021, all the essay questions, and we've actually used real life, excellent essay questions. These are the ones from the candidates who we took as pupils. They very kindly volunteered their own answers. But what we've done is we've done a kind of mishmash of a good but not very good answer, so that you can see what the difference is between and how you get the extra marks to push you through into an interview. So Srishti is going to kick that off, and I'm going to hand over to her, and she's going to do a nice piece of analysis so that you know exactly what you need to do. And after she does that, Olivia will do it, and then I've got a third, and then after that, Olivia and Alice are going to talk to you. They're obviously our most recent people who've been through the process about what they tried to do to make their application stand out. So here you go, Srishti.
Thank you very much. Rakaya, could I ask you to share the screen, please? Thank you so much. So one of the questions we had a couple of years ago was, in cases such as Charlie Gard, which is the case about end-of-life treatment that you may or may not remember, and whether or not to remove that from a child who is suffering quite a serious illness, it is no place of the court to dictate to parents where their child's best interests lie. So this first answer is good, but it's the one that Anarkali talked about as being an answer upon which we can improve in order to make it sort of reach the standard of the people that did eventually end up going to interview and being taken on. So if I could ask you just to scroll down a little bit, Rakaya, thank you. What's good about this answer is that it does engage with the theme. Now, the theme of this question is, what do we do effectively when what a parent wants conflicts with what the court might assess as being in a child's best interests? And to that end, there are some sort of critical analytical parts of this answer that show some promise. They're not perhaps worded in the best way, but they do pick up on those key conflicts. So for example, parents having context-specific information, whereas the law kind of being able to have a more detached standpoint in how it assesses a child's best interests, how it conducts that welfare assessment. There are parts where it engages with the particular theme of the question. For example, in the third paragraph, it talks about what kinds of emotions might have been playing on the consciousness of the parents in that case, what the judge concluded. Where this answer falls is, I think, fourfold. First of all, it's a little bit meandering. It's a little bit aimless in the way that it answers the question. It's very general. It sort of circles the point, but it never actually declares a proper point of view. And that's sort of betrayed by the second thing that I would say is a shortfall in this answer, which is its structure. We start off saying, you know, parents shouldn't have to be objective. Then we say, but for that reason, the court should be able to overtake a parent's wishes. Then we get what kind of reads like a description in the author's opinion of what the Charlie Gard case was about, but with not very much substance. And for the last part, we get a sort of throwaway analysis of the welfare checklist, which is a piece of law that we use. Now, one key part of the way in which we set essay questions is we don't expect robust legal knowledge. We don't really expect any legal knowledge at all. What we do say is if you're going to argue a point of view, argue it well. So should you choose to sort of cite law, where, for example, the author has done so in the fourth part or the fourth paragraph of this answer, make sure it's done accurately. That's the third point. Cite law if you like, be confident that it's accurate. For example, one of the things this answer says is, when children cannot contribute to the best interest assessment, their medical best interests override all other considerations. That's not quite how it works. It's much more nuanced than that. So if you're going to say something absolute, make sure it is qualified. Those are kind of the 4 points that I would say let this answer down. It's got promise, but it's not quite there. If I could ask you, Rakaya, to move to the next page. This is one of the answers that led this candidate to interview. And it expresses its view quite clearly at the outset. It says, I disagree with this proposition for 2 reasons, first, second. So that's the structure point met. The second point is this: it doesn't engage critically with the question of end-of-life treatment. It's not overly technical on the law. How it's interpreted the question, which is effectively about whether or not the court can ever supersede what a parent wants, is to look at it more generally. What do we do in every situation where that kind of conflict arises? And it's engaged with the law a little bit. It uses Re B, for example, where it's got quite a clear proposition. You only intervene in care cases in particular when there's harm to the child, not because you just don't agree that the parenting's good. That's not a high enough threshold to cross. It engages with a little bit of that legal analysis, but it doesn't go further than it's comfortable doing so. The second point is this: it does build on some of the ideas that are in the first answer. For example, it says courts have this objective standpoint from which they can work, but it doesn't make loaded assertions like parents, of course, shouldn't have to be objective and parents, of course, love their children. Those kinds of things are not what we can reasonably enter into our submissions when we're in court. Of course, we can touch on the emotional part of every case. Every case is emotionally charged in the family court. But to put that in such absolute terms can sometimes betray a lack of nuanced understanding, which you want to avoid, because actually emotional intelligence is such a huge part of how we have to approach this job. So that's what I would say about this answer. It reaches a strong conclusion, and it does so in a structured way, even if it's not overly specific about the law. The next answer was also a successful application, but you'll see that it's very different. This one is particular about life-sustaining medical treatment, and the propositions that it explores in doing that are specifically about those kinds of cases. Now, you might be wondering how 2 answers that are so different could have sort of led to the same outcome. But that's kind of the point that Alex was making earlier when he said there's no right answer, but the way in which you argue it, if you're going to advance a point of view, well, it's something we deal with a lot in this job. People have individual styles of advocacy. So certainly, if you set out the parameters of the question as you understand it, and you argue that well, then that's going to be a successful argument, provided it has that robust structure, that qualified analysis and nuance, a common thread that culminates in a really coherent conclusion. And it's just written in a way that reflects you've taken some time and attention. Now, I should have picked up on this. I apologize. That's, getting emails at this hour. It's part of the job. So might as well temper your expectations. But one part of the first answer as we were analysing it was the grammar. There were pieces with sort of throwaway sentences that hadn't been well thought out. But overall, that presentation aspect is really important. So even if you've got 2 completely different angles from which you're coming at the question, provided it's set out in this way, you can easily have a successful application. I think that's all the critical analysis that I'm going to do for now before I pass over to Olivia. But I think if we can circulate these afterwards, then we certainly will, so that you can consider them more closely in your own time as well.
Yeah, can I just interrupt there and say that we're going to be doing a sheet after this and sending it to everybody, which will have all the answers so that you can actually spend a bit more time going through them yourself and having a look at why we are saying the things that we're saying. Okay.
Thank you so much. Can I hand over to Olivia? Thank you.
Thank you, Shrishti. I'll just share my screen. So like Shrishti, there are two answers here. One is an answer which is good, but not fantastic. And we'll go through why it might miss a couple of the marks off. The second is an answer which is better, and the candidate who wrote that answer did ultimately receive an interview and was offered pupillage at Coram. So the four things really that we need to consider with any essay question, irrespective of what the question is. Firstly, a strong introduction. So from the outset, defining what the issue is, and if there is a test, setting out what that test is, and that just needs to be a line or two, nothing too long. Second, you need to then really grapple with the issue. So put your arguments for and your arguments against. And again, they should be separated into defined paragraphs so that it's easy to follow through. And with the arguments for, you're looking for ethical, moral, legal, whether there are any human rights issues at play. And the way that I would always do it is just do very brief notes, bullet points, for, against, before I then start making it into fully formed paragraphs. And then at the conclusion, just a very short paragraph or a line or two within a paragraph setting out exactly why you agree or you disagree with the proposition. And it's very important to come to a clear conclusion. And no matter what that conclusion is, as long as it's a well-reasoned argument, it doesn't matter whether the person reading it agrees or disagrees. So this answer, starts off by addressing what the issue is, and that is that, or the legal issue really is whether a child is at risk of suffering harm in the parent's care, which would then mean that they should be removed from that parent. So it sets out what the Children Act states in so many words, and then goes on to say that there must be evidence that it's in the child's welfare interest to be removed. So that's all correct, but potentially could be worded slightly better. Going on to the second paragraph, which is really the reasons for, it states that harm could be physical, emotional, psychological. What it doesn't do is set out exactly what that harm is. So if I was answering this question, I would probably define what I meant by that. So what emotional harm could be caused to a child whose parents believe in the teachings of ISIS? What potential physical harm or what potential psychological harm could stem from that, rather than just making general assertions of harm in general. Then turning to the next paragraph, again, it does grapple with the issues to a certain extent. And that is that ultimately, irrespective of the beliefs that a parent holds, if they're not propagating those beliefs to their child, then arguably there's no risk of harm to the child. And it does grapple with that to a certain extent. Going then on to the fourth paragraph, it does mention human rights, which in any question that we're likely to ask you to answer, there's always going to be a human rights issue at play, whether it's the Charlie Gard question, which Shrishti just went through, or this question, which is about parents who might believe or follow fundamentalist ideologies. So there are human rights issues at play, and it's always really important to identify those. However, this question, although it does mention human rights and potential interference or breach of human rights, it doesn't specify what those are. So that's always very important as well, to set out exactly what you mean if you're mentioning human rights. Finally, it comes to a conclusion, but it does start with, in my opinion, and I would recommend in an essay question never mentioning your opinion. If you were writing written submissions to a court, you wouldn't say I believe or I think. It would always be X's view or Y's view, rather than your own personal opinion. So I would keep away from that if possible. Going on then to the question, the answer which received the higher marks. it does really hit all of the criteria I've mentioned. So there's a strong start, setting out exactly what the issue is that we're addressing. Then it goes on to the arguments for the proposition. So the reasons why a child might suffer harm or might be removed from their parents if their parents do follow the teachings of ISIS. And it really defines what that harm is. So emotional trauma through exposure to violence or extremist propaganda, potential physical harm in very extreme cases. And it really does grapple with the issues. Then going on to the arguments, I'll call them the arguments against. So the other considerations that we have to have when looking at this issue, and this issue does come before the court on a fairly regular basis. And it does, again, grapple with that issue. It does discuss human rights and specifies what those human rights are. So right to family life and freedom of religion. And as Shrishti said, we're not looking for you to be able to cite Article 8 in full. What we're looking for is for you to be able to identify what the potential human right issue is that arises in this particular case and mention it in brief. Then finally, it finishes with the conclusion, and it's a balanced conclusion. So it doesn't go to one side or the other. It definitely remove or definitely don't remove. It's more nuanced than that, and it looks at the arguments for and the arguments against, and whether there are more proportionate steps that the court could take rather than sanctioning removal straight away, and then comes to that conclusion. So the second answer does really hit all of the criteria that we would be looking for, and it's also well structured. So starting sentences with further, for example, and I'll go on when I discuss with Alice how to structure your pupillage application more generally, that it's always good to make sure that your paragraphs are very well defined and follow a very clear structure, so that when the reader's going through your application form, they're not getting lost in dense paragraphs and lots of information. Thank you. Back to Anarchy.
Thanks so much, Olivia. Great. So what I'm going to do is just see if I can share my screen. Here we go. I'm hoping that will work. And what we have here is the essay topic was civil partnership for opposite sex couples is unnecessary. I think that's our most recent one, actually. I think I did the 2021 cohort, and I kind of put together an answer which represented the sort of answers that don't make it through to an interview. And what I would say is that this isn't a bad answer. It's plainly been thought up and written down by somebody who's put a bit of thought into it. And that's kind of, in a way, the real tragedy of this, because there are actually quite a lot of good thoughts. But what I want to show you is how, if you develop those thoughts, you're going to get a better chance of getting those interviews. And I'm going to show you some of the things that personally really irritate me when I go through these forms, which I have done for a few years now. So the first thing that really drives me bananas is when people start their essay questions with what I would describe as fluff. And the first sentence of this is a really good example, in my opinion, of fluff. So saying the proposals for opposite sex civil partnership have been met with severe criticism and are considered by some to be highly controversial, in my opinion, as the marker of this essay, is fluff, because it's got nothing to do with the necessity or otherwise of opposite sex couple civil partnership. And I would say one of the pitfalls of this answer overall, and certainly once you read it for yourself, maybe you'll agree, is that what it does is it actually debates civil partnership for opposite sex couples instead of the question, which is the necessity or otherwise of those. And what we'll find time and time again in these answers is that they're not really engaging with the question itself in a meaningful way. And those questions that distinguish the answers that distinguish themselves are the ones that really, really engage with the question itself. Okay, so here we have the first thing the first idea that they're developing is that basically, the fact that single-sex couples have got the choice of a civil partnership and a marriage it shows, doesn't it, that this has not been a straightforward path for them. But I think it's being suggested that their experience and their struggle would be trivialized if heterosexual couples could be civil partners too. And I think when somebody puts quite a bold idea, I mean, it's quite a creative idea, I'll give them credit for that, but I think this is again not really going to the question of necessity in any meaningful way, but also this is quite it goes to a common mistake which you will find both at written application stage and also during your interview, which is that people tend to overstate their case. And what I really want you to take away from the session is that the best argument is a nuanced argument. It doesn't mean that it's a wishy-washy argument, but it's an argument which really takes into account the multiplicity of viewpoints around a controversial question of this nature. Okay, so that, in my opinion, is somebody going off on a bit of a frolic, and it's really difficult to really see how any of that first paragraph is directly related to the answer to the question that this person is supposed to be answering. Now, what we then go on to a second paragraph that says, I would argue that even if there is very little legal or material difference between civil partnership and marriage, the biggest appeal for many is that it's not marriage. Now, actually, what I would expect somebody to do, even if they are not lawyers, which you may well not be at this stage, is recognise that there isn't any legal difference between civil partnership and marriage. There is no legal difference whatsoever. And that, of course, has got to go to the necessity of this. It goes to the heart of the argument. Why are we having an identical scheme with two different names being set up? And this answer doesn't properly acknowledge that heart, which really lies at the issue which lies at the heart of this question. It talks about societal norms, but again in too overly a sweeping way. So here we go. Marriage carries with it many outdated social norms. That, to me, is a problem when I read it, because what we have are men and women up and down the country who are engaging in marriage, and so many of these women are promising to obey their husbands, even in this day and age. So it's really very difficult, in my opinion, to argue that these are outdated societal norms when we actually know that so many couples up and down the country still engage with them in a meaningful way. But the point I think that the writer is trying to make is that not everybody does share those societal norms. And if they'd been able to explain that in a more nuanced way, this argument would carry more weight. And then you've got, I think what I tried to convey when I put together this answer is it's a bit too colloquial as well. The tone of this answer is far too colloquial. And you will get people who do things such as, which puts them off the whole thing altogether. And the difficulty with a colloquial answer of this nature, I don't expect you to, I don't expect a sophisticated argument being put together with loads and loads of long words or Latinate words. But I think you need to recognise that when you're putting arguments on behalf of other people, you enter a different type of register to the one that you normally engage with when you're chatting to your friends or when you're even speaking out loud. For most of us, what we write down is in a different register to what we say to each other. And I would expect you to demonstrate that in your answer as well on some level. Now, the third paragraph here mentions the most relevant judgment, and that's wonderful, because I would love to see that. And we didn't see that in all of the answers. And it was actually a very relevant, like it is the judgment of this thing. And at the time when we set this question, I would have expected everyone to have been aware of that. But what it doesn't do is really tease out any of the issues here. It just says, for this reason, it was only legalized. Now, a better answer, and the one that we'll go on to, really explores what the discrimination point here, which is actually a really fascinating point. And that's where this writer is losing points, because what this writer is not doing is really following through in a sophisticated way the implications of that judgment. It mentions the judgment. If you want to get all of your marks, you want to explore those implications. And then lastly, you've got this: in conclusion, if civil partnership is to be allowed for single-sex couples, then this position holds true for heterosexual couples. And if it's to be abolished, then it should be removed for couples now that marriage is possible for everyone. I mean, that just doesn't go really to the question of necessity. I mean, it could be related to, but what this writer doesn't do is relate it specifically to the question of necessity. And a better answer, as you will go on to see, does exactly that. Now, this is the better answer with which we compare the moderate or mediocre answer. And first of all, we've got quite a punchy start. And as we scroll down, you will see that there are two reasons that this writer gives. But what is quite interesting about the way that the writer develops these arguments is that they are actually based on pulling out those discrimination points and really running with them. And this makes a really nice, nuanced, intelligent, and readable answer. It's actually quite a persuasive argument, because it really covers so many more bases, and not in the superficial way that the first answer does that. So what I really loved about the first point of this answer is that it explains why it's necessary, and the reason it's necessary is because what we know about marriage, people who are married, is that typically it's women who lose when those relationships go wrong. And so we have an indirect discrimination point there. And so arguably that's justified on the basis of necessity is justified on the basis of indirect discrimination. And the second point, which goes again to that discrimination point and develops it further, is obviously that the government, by only allowing same-sex couples to enter into civil partnerships, discriminates against mixed-sex couples, and that discrimination is unlawful, and therefore it's necessary for our state not to discriminate. I mean, that's a really important point, which actually the first answer really didn't develop in any meaningful way. So what the second answer does, I hope you can see, is really show that it really develops the theme of necessity or unnecessariness. That's not really a word, but you know what I mean. But also, actually, it does it in quite the writing. It's tight writing. It's really nicely written. It's quite persuasive because it's nicely written, and it's to the point in a way that the first answer isn't. This first answer I would describe as somewhat waffly. So for that reason, we would typically give the second answer a lot more marks. So again, I really hope that explains it. I'm going to stop sharing now. We'll go back to the main screen. And now what I'm going to ask Olivia and Alice to do is explain to you what they tried to do when they were tailoring their applications, in the hope that this is something you can learn for and tailor your applications similarly.
Thank you, Anarkali. So I will start and invite Alice to jump in as and when. So it will be both of us you'll be hearing from. Firstly, in terms of the answers, there are a couple of general points that I wanted to make. And that is, before you start writing any application form, really think about what this Chambers is looking for. So in this case, where you'd be applying for Coram for family law, there are, in my view, four main points, and there are other points, but these are the four main ones that when I was writing my applications, I thought about. And the first one's oral advocacy. You're going to be in court a lot from very early on, and it's vital that you've got good advocacy skills. Second, written advocacy skills. that's expected before every case. You put together a position statement or a skeleton argument, and you need to make sure that you're able to persuade on paper. Often you have half an hour for a hearing, and the judge has read your position statement and doesn't have much time beyond that. So it's very important that you have strong written advocacy skills. Third, client management skills. And that's both your professional client and your lay client as well. And fourth, research skills. A very large part of this job is being able to find answers to questions quickly, and you don't have a big team to support you in doing that. So you have to work out how you're going to get the answer to your question as swiftly as possible. And as part of that, you therefore need to have good research skills. Alice, was there anything else from you particularly that you thought about?
Well, yeah, I completely agree with you on those points. I think what I did was after I'd identified the points that I wanted to draw out, I then went to my CV and said, what's going to provide the best example for those? Because you might have jobs which show both oral advocacy and client management. But if you've already showed client management somewhere else, maybe focus on the oral advocacy and really draw that out in that example.
Exactly. And as Alex said, this doesn't need to be, I've been a judicial assistant in the Court of Appeal to show that you've got good research skills, or that you've got experience working with senior professionals. It could be your job in Tesco, working with your manager and communicating with a more senior individual on that basis, or communicating on a day-to-day basis with people who come into the supermarket who you're serving. So it doesn't necessarily have to be legal work experience to demonstrate these criteria. Another more general point, which crosses over every answer that you're answering, is structure. It's very important that your answers are very well structured, because your marker needs to be taken through it in a clear and structured format. So for the general questions like scholarships and positions of responsibility, prizes, I used subheadings and bullet points. So rather than writing long-winded paragraphs, I would put subheading, positions of responsibility, underneath that bullet point 1, bullet point 2, bullet point 3, with a very brief discussion of explanation of what I'd done and the dates, and that was it. So keep it short, keep it concise wherever possible. For the longer questions, so for example, why this Chambers, or what makes a successful barrister, I again numbered my paragraphs. So I would say first, secondly, thirdly, fourthly, finally. So again, taking each point in turn and structuring it in a clear and concise way. For those questions, so the longer questions of for example, skills necessary to become a successful barrister, or what you've learned from mini pupillages, you always need to link your experience, whatever that experience is, back to the question all the way through. So try not to make generalized comments like, I want to be a barrister because I enjoy advocacy and I've got strong advocacy skills. You need to link it back. So skills of a successful barrister, they're able to persuade, and I've done X, Y, and Z. So it's always, this is the assertion and this is what I've done to show that I can meet that. And whether that's mooting or debating, free representation unit, anything, as long as you can associate something you've done, your experience, with what makes a successful barrister, that's going to get you the higher points, because you're saying this is what it takes to succeed, and this is what I've done to show that I can succeed. It's also acceptable within the application form to cross-reference. So if under the heading of examples of mooting and debating, you've set that all out in detail, you don't then, in your answer of what makes a successful barrister, need to start writing about that all over again. In my view, it's perfectly acceptable to say, I've been successful in mooting and debating, see paragraph 5 above, rather than setting out again, I've done X, Y, and Z moot, because it just takes up words and you're already limited for words within the application form. Anything else, Alice, on that point?
No, I would just emphasize the conciseness element that you were just talking about. It's so important to just say your point and say it well, and then leave it and then move on to the next thing.
Yeah, exactly. And try and avoid repetition. So if you've discussed, as Alice said, if you've said, I've shown good oral advocacy skills in this respect, then try not to use that example again and again and again. Try and pick a different example if you can. And, you know, some people will have more experience than others, particularly if you're early on in your legal career. So if you're, you know, second year or third year law student, you're likely to have less experience than somebody who's done their BPTC and masters and has been working for a year or two. So it doesn't matter if you don't have reams and reams and reams of experience, as long as you can link it to what we're looking for. Going back to the generalized comments point, we see that quite often in respect of, I think there's a question around why, what mini pupillage you've done and why that's made the family bar attractive to you. Again, try and not make generalized comments in that regard, because saying things like, I enjoy legally complex cases, or I enjoy advocacy, that's synonymous in every area of law, whether you're doing tax law, whether you're at the Chancery Bar, whether you're doing family law, it's all going to be legally complex. So try and think about specifically what it is about family law that you enjoy. And if you really do want to practice family law, that shouldn't be that difficult, because there are a few things which are prominent in family law that you're not going to get in other areas. So, for example, working on cases which have a profound impact on the lives of the litigants that you're working with, or being in court often. So a family practitioner is in court a lot more than a commercial barrister would be. So try and think about that and specify exactly why family law, rather than making very general assertions. Anything else, Alice, from you?
Well, I had done a lot of minis that weren't in family specifically, but still I was able to draw out what about those minis did I enjoy or not enjoy, and why that was then applicable to family law in particular. So if I'd done a crime mini, I maybe talked about dealing with vulnerable clients, or if I'd done a more civil mini, then it would be about complex litigation or putting together a skeleton argument. But it was about drawing out what it is about those minis that had meant, yes, I've firmly decided that family law is the right way to go for me.
Yeah, and we're not expecting you to only have ever done family minis. We'll expect you to have tried different areas out and decided what you like and what you don't like before making your application form. So if you've got 5 commercial mini pupillages behind you, that's not going to go against you by any means, as long as you can draw out what you've learned from that and why it's improved you as a candidate for this application form. And yes, as Alice said, one of the main qualities that we're looking for, I think is very important, particularly as a junior practitioner, is the ability to work with all sorts of different people. So your professional clients, but also your lay clients. And if you're doing care work or domestic abuse cases, you're going to be working with some very vulnerable individuals. So examples of when you've done that, it is always going to work well. And that doesn't just need to be legal work experience. As I've said, that could be anything. I think that's everything from me, unless you wanted to add anything else, Alice.
No, I think that's everything.
Thank you both so much. That was so, because it's been such a while since I've done it. It's been so fascinating to hear you talk about it. So I really hope that I'm sure it will help all the people who listen to it. We have a few questions, and Rakaya has really helpfully amalgamated those questions. We are going to allow people in the audience to ask questions, but some were submitted in advance, and it might be a good idea to go through those now. So Rakaya, can you help us with what the first one was, please?
Yeah, of course. So here we go. This was submitted earlier this week. I'm in second year law, and my question is, due to COVID-19 and caring for 2 children, getting actual work experience has been difficult. Although I run the Sabina Nessa project and am involved in mentoring schemes, how important is work experience when applying for mini pupillages?
Okay, so I'm going to answer this one, if I may, because it goes on to a point I wanted to make about caring responsibilities. And the point I want to make about caring responsibilities is that we are very aware that if you have significant caring responsibilities, it may affect your ability to engage with mini pupillages, work experience, marshalling, all of the stuff that you're always told to do. And I really want to make it clear that you can still succeed in your application, if you use the experience you have of caring for your family members or your children, there will still be examples that you have come across that you can put on your form, and we want to read them and we want you to apply, because the bar needs your experience. Okay, so if you have, that's the first point I make. But to actually deal with your question, which is how do I overcome this as an obstacle when I'm applying for mini pupillages? In terms of the mini pupillage application process, like, that's a slightly different one that we're dealing with today. And but I think there's a form there, and like I say, you'll be able to use the experience that you've already had to kind of help with that. If you don't have many mini pupillages, it's not going to be fatal to your application. Okay, you particularly in a year where people haven't been able to leave the house, and we as a Chambers are very aware that we haven't been able to offer the number of mini pupillages we typically would, because everything's been done remotely. If you put that down, and if you say that you've attended webinars, you've tried to make up for it in different ways, you've read stuff, you've read blogs, this is the way that you've tried to understand and get to grips with what a career at the bar is likely to look at. That's the way that I would approach that gap in your experience. You can make up for it and be creative in different ways. It's not fatal. Okay, I hope that answers that question in a meaningful way.
I think it does. So we're on to the next one, which is it appropriate to use subheadings and bullet points in the application, especially in section 5?
Well, I think Alex dealt with that, but I'm going to put you over to Sushri, because I'm sure she'll give you a wonderful answer.
Well, my sort of view on this is yes, if it's conducive to the structure and it's sort of expressed well. I think from memory, I may have used subheadings and bullet points in my application, and I'm here. So I think it's not fatal, but it can actually help as well if you're going through volumes of applications. I think Alex mentioned earlier, you're going to be one of a pile. If it draws our eye to the key points and it's expressed well, then why not?
And I second that. I'm looking at my application form now, and in section 5 use subheadings and bullet points, and I'm also here now. So
yeah, I'll third that. Did exactly the same.
Great.
Brilliant.
Thank you, everyone. Rakaya.
Okay, so how much ADR, particularly mediation, is done by Coram? Is there scope for this to be a large part of practice?
In short, the answer to that is yes. We have a never increasing and expanding ADR group, and mediation and arbitration is something that many of our barristers are very interested in doing, and in fact do on a daily basis. So the answer is yes. It's great, particularly now that there are huge court delays. It makes sense to try and move as much work as we can out of the court arena with all the uncertainties that surround hearings at the moment.
I'd like to add to that if I can, and say that's one part of it. The other part is if you want to sort of do mediation training. I'm a trained civil and commercial mediator, randomly, because why not? And the clerks are really supportive in helping you sort of manage your diary and do the training and attend all the CPD days and put in actual mediations and demonstrations if that's something you want. So scope for it all round, I think.
Cool, thank you. The final one is a really interesting question, actually. It came directly to our inbox the other day. I'm currently a third-year law student. I want to inquire if it would be possible to apply for pupillage with the October 2023 start, despite not having completed my BTC. I intend to start the BTC this September 2022. Due to this, I would be unable to complete some sections in the application form. Should I still apply?
Olivia, can you help this lady or gentleman with this one, please?
Yes, you definitely can. So if you apply for 2023 intake, you'd finish your BPTC in around, I think it's around June or July of 2023. Pupillage starts in October. So as long as you pass all of your exams, then you'd be okay to start. I think you have to just let the BSB know you're expecting your exam results to come through, and as long as they come through within a reasonable time of you starting pupillage, then you're good to go. So you definitely can still apply.
Thank you so much. I think those are the questions that we received in advance. I don't know if anybody has any questions. We're slightly running over time, which always happens with webinars. So don't feel under any pressure, but please do ask us questions. We really do. I mean, the whole point of this is that we're trying to help you with all of this. So I don't know, Rakaya, how maybe they put that in the chat.
I think that would be the easiest way, yes, is just to stick your question in the chat. Don't be shy. Ah, there we go. Right. Can you explain what the division of work Coram does in terms of financial remedy work and child law?
So, Susanna, I would say that we're a set that really covers all of those areas. And in terms of, like, is it a 50-50 split or a 40-60 split? It's actually very difficult for me to give you that sort of information at the tips of my fingers, because I don't know it and I don't have it. But I would say that we are a set that really does pride itself on being able to offer the whole spectrum of family law advice and representation. I would say that we're probably more well known for child-focused law, but I wouldn't want anybody to take from that it's certainly during pupillage, you would be offered the exposure to all of the areas that we do as a set, which involves COP work, public law work, private law work, financial remedies. And as you're a junior tenant, I would expect you to be doing all of that work as a matter of course and routine. Srishti and Olivia, I don't know if you can help me with this.
Yeah, absolutely. I was going to say that Olivia, Sam, who's another colleague of ours, who's a recent tenant, and I think we all did finance seats during pupillage. There is a really strong finance team, and even now my practice is, I wouldn't say even, but that's actually more out of choice than anything. I know that if your choice is sort of to veer more towards finance work, that's definitely something you're supported in as well. But I certainly do quite a lot of finance as well. There's a lot of private children law that we do. The junior end kind of has mixed practices all round.
Yeah, I would second that. I would say mine is probably closer to 50-50 even than Shrishti's. I do a lot of finance work. So next week, I think I'm purely finance. But I also do public children and private children as well. And as Anarkali said, as I, during my pupillage, was able to do quite a lot of quarter protection work as well. So you really do get the broad spectrum of everything Coram does during pupillage.
Okay, so the next question is, if you haven't yet completed your undergraduate degree, how will the academic achievement section be marked? I mean, I think the thing is, I think Ginny was explaining, you might be able to update us when you get the results through, but actually we would expect you to be applying between after you've got your results and before you've done your BBC. That would probably be the earliest. If you do want to make an application before then, you would you would do that, and like I say, you would update the results with us. But I hope that Alex has explained that it's not just academic, the undergraduate part that we mark. We also mark results before then, and any qualifications afterwards. It's actually quite unusual, I would say. The reason I'm a little bit thrown by this question, if I'm honest, is because it's actually really, really unusual for us to receive an application from somebody who doesn't have their degree. Not least because actually there's so much training that's involved in being a barrister, but if you are on course for good results, there's no reason why you shouldn't apply. I wonder, Srishi, are you able to deal with the mini pupillage one that's in the chat?
Sorry, I'm still muted, absolutely. is it the case that you're offering mini pupilages at present, just a limited number? I have looked at your website, but I'm not totally clear on what the situation is. I'll be corrected if I'm wrong. I think we're starting to reintroduce mini pupilages, but it's been difficult because of the pandemic, because we want people to have time in court. And a lot of the time, actually, even if we have hearings that are nominally listed to be heard in an actual court in front of a judge in person, they're being moved to be remote now. There are other schemes through which we partner with Bridging the Bar, for example, which is also a scheme I work on. So accidental plug, but I'm not going to say sorry for it. There's opportunities to get mini pupillage there, but in order to actually set it up and make sure that it's something that you'll get the best possible experience out of, I think we're also waiting for more clarity with the pandemic situation. I don't know, Anarkali, if you'd wish to sort of add to that.
So we're Bridging the Bar is one of a number of schemes that we're signed up to, and in practice what it means is that if we offer, say, 26 mini pupillages a year, which is every other week, as I'm sure you've worked out, a half of those proportionately are kind of tied up with like people who don't come from traditional backgrounds. So that means you've got fewer to apply for in the traditional way. I'm not sure, we've got a massive bottleneck of mini pupillage applications at the moment because of the pandemic and because everybody is so much more desperate to get hold of them. And it just means we have a huge backlog. And I suspect if you're applying for pupillage at the moment, it may be that you just don't get mini pupillages and you're one of many who are going to have to make applications without mini pupillage experience. But like I say, there are ways to make up for that. I'm not trying to pretend it's okay, because it's not. We would love to be able to offer more, and we would love to be able to offer ones that were more meaningful, but we just can't. It's very difficult at the moment, because if we do have a mini pupil, we just can't guarantee them the physical work in court, because so much of it is being done remotely.
If I can jump in there, actually we have had some people come in for remote mini pupillages. So to that end, I'm being told by our wonderful Ginny, who's also on this call, that if we can sort of accommodate more mini pupillages, if you put your application in, we'll do our absolute best to facilitate you. But in terms of the authenticity of that experience and actually being in person, we do have restrictions on that, as does every other workplace. We're not penalising anybody for not being able to undertake mini pupillages in these application rounds, though. I think everybody across the bar understands how difficult that has been.
Yeah, can you just please remember what Alex said, which was that you don't get any marks, certainly on our part, for having done mini pupillages. What you get marks for is kind of relating experiences that you've had, or like comparable experiences. And think about it, it's a week that you're investing in these minis. And so it's not a great return on marks for the time that you're investing. So think about what else you can do, and there is stuff that you can do. So the last question is that I think we'll deal with, because we really do need to all have dinner now. I'm going to ask Olivia, would you be able to do this one? It's from Karima, and she's saying, as this type of work is one that can be extremely distressing, does Coram offer mental health support? I imagine it's very testing at times.
So it can be testing, particularly as a junior tenant. You're being exposed to lots of issues which are very sensitive, and it can be upsetting at times. But Coram has a very collegiate atmosphere. So I know that if ever I have a hard case or an issue which I have found personally challenging, then I can pick up the phone and there are 10 different people who will answer immediately to have a chat with me about it. So I've never found that a concern. During pupillage, you obviously have your pupillage supervisor, and you also have other resources within Chambers. There are also other schemes that Coram runs. So for example, I don't know whether it's operational at the moment, but I know that we were doing wellness, things like yoga. There were online yoga classes that we were invited to do. And there are other opportunities as well for sort of wellness training and wellness events that go through Chambers. So from my knowledge, that's what is available. In terms of specific mental health support, in terms of counselling, I'm not aware that that's something which goes through Chambers.
Can I jump in there and just say Inns of Court have counselling services that they offer, but also professional networks like the Family Law Bar Association. They do assist if you reach out to them, because they're sort of aware of the challenges we face in our working environment as well. But Olivia's absolutely right. We have Chambers Wellbeing Officers. We have the sort of support of our fellow employees or tenants, and we do have initiatives that we do our best to run, because it's been so difficult also during this pandemic to just be able to see people and be around them and know that you can kind of have a quiet moan and a cup of tea in person and not on a screen. So those are certainly things that we take very seriously as part of the working atmosphere here.
I would agree, and I just want to make it clear that the work that you do as a family barrister is at times gruesome, and it can be quite brutalizing, and that there is no way to finesse that. It is a difficult job. Sometimes you take it home and it sits with you, and we all need to take responsibility for that. But as a Chambers, because everybody is self-employed, the best thing we can do is signpost people to resources and provide the sort of environment which I think Coram in particular is famous for. This is an incredibly warm and supportive environment. I cannot think of a single occasion where I have ever sought support or assistance or help from anybody who has not been prepared to do it. And it's one of the absolute blessings of working at this set. It is an absolute joy. I hope that even in the webinar that we have run today, you will have sensed some of the warmth that we enjoy in our set and the genuine sense of friendliness. And I really hope that you do make an application as a result, but because it is genuine. Anyway, we're going to wrap up now, and I really want to thank all of you for participating in the way that you have. And I really hope that this has been so helpful for you, and really help, like I say, we just want you to get over the edge. We want to see you in those interviews. And I hope if you study the sheet that we give you, you'll be able to know how to just add those few marks on, because that's what will make the difference. And if you have any further questions, please feel free to ask us afterwards, and we'll do our best to get back to you.